Welcome. We're so glad you're here with us for today's Harper Lecture. The Harper Lecture series began in 1979 with Hannah Holborn Gray speaking in San Francisco. As the need for critical thought remains apparent in all areas of life, we proudly continue this signature program to bring you stimulating conversations and fresh ideas. Our UChicago community is a global one, and we are thrilled that technology can help us stay connected to one another. As you enjoy today's lecture, please note the following items. Your camera and video will be off. However, we encourage you to ask questions. Please use the Q&A box at the bottom of your screen to ask a question at any time during the talk. Closed captions are available by clicking the box at the bottom of your screen. Click Show Subtitles to enable this feature. If you're having trouble with audio or video, please try shutting down programs in the background, or you can dial in from your phone. Thank you once more for joining us. We couldn't do this without you. Hello, everyone. Welcome to today's Harper Lecture, The Failure of the World's Richest Countries to Restrain Law Enforcement with Professor Claudia Flores. I'm Andrea Hodgman, Associate Director for Intellectual Engagement and Travel and the Program Manager for the Harper Lecture Series. I'm so happy you're here. On behalf of everyone at the University of Chicago Alumni Office, thank you for joining us. Please allow me to introduce our moderator. Tom Ginsberg is the Leo Spitz Professor of International Law, Ludwig and Hilda Wolf Research Scholar, and Professor of Political Science. Professor Ginsberg focuses on comparative and international law from an interdisciplinary perspective. His latest book, Democracies and International Law, was published last week. He also wrote How to Save a Constitutional Democracy with Professor Aziz Huq. He currently co-directs the Comparative Constitutions Project, an effort funded by the National Science Foundation to gather and analyze the constitutions of all independent nation states since 1789. He and Professor Flores co-host the recently started podcast entitled, where they explore the stories and thorny questions around why rights matter and what's the matter with rights. Professors Flores and Ginsberg, thank you for joining us. Professor Ginsberg, I'll hand things over to you.
Thank you so much, Andrea, and thanks to everyone for spending some of your evening with us. Everyone at the university is really grateful for all of you who contribute to our university life and participate with us in our projects. So tonight's lecturer is Claudia Flores. She's a clinical professor of law here at the University of Chicago Law School and director of our Global Human Rights Clinic, which is a clinical program directed to advancing global justice by strengthening human rights institutions and communities around the world. Under her direction, the Human Rights Clinic has received international recognition and featured in the Washington Post, NPR, the Chicago Tribune, the Guardian, the ABA Journal, and many other places, bringing glory to the law school. She's a graduate of the college as well as NYU School of Law. And if I can add a personal note, we've been working really closely together for the last few months on a new project, which is a podcast coming out of the law school entitled, interestingly enough, that's the name of the podcast. It's a podcast about rights around the world and why they matter and what's wrong with them is our title. And without further ado, I'll turn things over to Professor Flores.
Thank you so much, Professor Ginsberg, and thank you to the Alumni Office and to our wonderful alumni and donors. I'm really honored and so pleased to speak with you this evening, and also especially grateful that you've joined us for this Zoom version of the Harper Lecture. As Professor Ginsberg mentioned, I am a 1997 alumni of the undergraduate program here at UChicago, a philosophy major, and am continually sort of a little amused when I walk back to main campus and go back to Cobb Coffee Shop where I worked when I was an undergraduate. So I'm very excited to be here and to talk with you. So I'm going to spend my time talking with you about some research that I did as director of the Human Rights Clinic here at the law school, along with collaborators and actually law students at the law school on police lethal use of force. I'm going to start first by sharing with you what motivates motivated this research, and then step back a little bit and talk about the context in which this research sits. And then I'm going to talk to you about our findings in this research. The clinic has been involved with the issue of lethal use of force of the police, law enforcement around the world, and both in the United States now for about 4 or 5 years. And we've done a series of research projects that have led to some really interesting observations that we think are important in this moment when we're thinking about the role of law enforcement in society. And what I'm hoping to share with you today is that this is not just a domestic question and a domestic inquiry, but that it's actually a global question and a global inquiry, and that the reports around the world indicate that the same kinds of challenges can be found in many different country contexts, and that it's actually worth thinking about this issue and how the state and the citizens of the state should require that law enforcement is restrained in an international context. So let me first share with you why we bothered to do this research in the first place. So as Professor Ginsberg mentioned, the Global Human Rights Clinic works advocating for international human rights, and the students in the law school essentially work on behalf of clients. And we have international organizations, UN bodies, governments often approaching us and asking us to support them in advocacy projects and research projects, essentially usually high-level, complicated human rights questions that we're well suited to take on. And so this project originated with a request from Amnesty International. Amnesty International had issued a report, I think it was in 2015, in which they looked at all of the state laws that regulate or constrain police lethal use of force in the United States. So they looked at the 50 states and the laws in the 50 states to see if those laws complied with international human rights standards. And what they found is that none of the laws in the United States complied with these standards. And I'll explain to you more what these standards are. But the response from the states was that actually lethal use of force by the police isn't really contained in state laws, that actually it's contained in policies. And so what they asked us to do is to look at police department policies, which is where they were told the meat of these restraints was placed, to look at those policies to determine if they complied with international human rights standards. So we did this and issued a report, Deadly Discretion, in 2020, which also found that none of the policies complied with international human rights standards. And then after we issued that report, and I'm starting to share my screen because I'm going to start going into more of the details of our study, we were then approached by The Guardian, the newspaper, who asked us to then do a global study. So what I'm going to talk to you about today is this global study and the results from the global study. And the global study focused on the 29 wealthiest countries by gross domestic product. And we looked at the largest cities within each country. And I'll explain to you why we've done this research at the city level. But that's the research that I'll be discussing with you today. Okay, so let me first explain to you why this is a global question. So whether or not law enforcement can use lethal use of force against citizens. So just to be clear, this is force that can cause death or serious bodily injury, implicates some really important basic rights. So the right to life, freedom from discrimination, due process, speech, assembly, and protest. You've probably heard news stories of, and in the United States and actually globally, in which lethal force was used by the police in the context of expression, protest, and assembly, arbitrary arrest, and freedom from torture. So these are really basic rights that are contained in international human rights treaties that most countries have ratified and agreed to. So the question of whether or not the police can use this level of force actually has very serious international human rights implications that are relevant at the global level. The other reason this is a global question is because of the patterns that have emerged of law enforcement targeting of marginal groups. So you're probably familiar with, all of the media around George Floyd and the many others who were killed by police in circumstances that indicated that there was an abuse of power. Those kinds of reports have been coming out of countries around the world, especially in the last 2 years, because there have been more efforts in the last 2 to 5 years to really collect this information. So we're seeing similar patterns in different countries. And then the third reason or justification for thinking about this with a global scope is that the lack of transparency on policies, processes, and data is incredibly consistent. The countries that actually collect data and make data available on policies, laws, police shootings, the circumstances for police shootings, the number of people that are shot by the police. They're the exception and not the rule. And so this is concerning. You know, we collect data on all kinds of public health measures and other measures that that tell us whether or not our governments are doing a good job and whether or not the state is actually fulfilling its services. And we don't have data in most countries on how the police are using this awesome power that they've been given. And I'm trying to pass my slide. Okay, there we go. Sorry about that. So one of the reports that that we have found consistently in various country contexts, and again, as I mentioned, there's very limited data available, but the data that is available usually is collected in private research studies, indicates that there is an issue with ethnic and racial discrimination and policing, not just in the United States, but in other countries as well. So what we've seen in various country contexts is that Black and brown people are more likely to be shot and killed by the police than white people. There's a study in Canada by the Ontario Human Rights Commission that found that a Black person in Canada was 20 times more likely to be shot and killed by a police officer. In Brazil, you find a similar study that found that Brazilians of African descent accounted for 75% of all police killings. In France, someone perceived by a police officer as Arab or Black was 20 times more likely to be subject to a stop and search. So these kinds of studies are numerous. And so there's clearly a pattern of a disproportionate targeting, under policing and over policing of ethnic populations within countries by the police. Now, as we're looking at all of this information, we think about these contextual questions, right? What role do the police play in our communities? The police have a broad mandate in most countries to identify and resolve conflicts, to maintain order and peace, and perform some element of social control. And the mandate is broad and it impacts our everyday lives. So, they respond to crimes, they manage protests, they guard schools in some neighborhoods, directing traffic, respond to mental health emergencies, and enforce orders of protection. The question that advocates have been asking themselves as these reports have become more and more prevalent is whether or not they're playing these roles effectively. In some of these circumstances, would other government services be more effective? And does modern law enforcement, in the way that it's conceived, continue to fit the needs and values of society? So these are kind of the overarching background questions behind the work that we're doing and the work that others are doing to assess whether or not police are using force in a proper manner. Just a quick background of policing, the structures and institutions that have shaped our current policing, and this is a general global assessment, is basically a lot of the police structures in many countries are based on military organizations. They find their roots in colonialism, so ensuring that colonies complied with what the colonial powers wanted. And in the United States, for example, the roots of our police and the way that it's organized also are connected to slavery. So the legacy that these institutions have left have led some to ask, should we abolish them in their current form? Should we consider defunding? Should we invest in more in other social services? To give you an example, in the context of protests, a number of researchers and advocates have suggested that instead of having so much police presence in a protest, instead you would focus on having a different element of the government that assists in organizing a protest and making sure that it's orderly, having emergency services, maybe streets and sanitation, but that police actually tend to escalate the heat of a protest and are more likely to make protests go in directions that we don't want them to go. So there's an understanding that there might be a different way of doing things. The police have a monopoly on state violence against citizenry, and that's really something to keep in mind as we're having this discussion. There's that the state can turn in a violent manner on its own people is an awesome power. And so it's an awesome power that must be significantly restricted. Now, when I speak about lethal force, I've defined it more or less, but I'm talking not just about firearms, but the use of the body, irritants, instruments, special equipment that has the potential or the intention to inflict serious bodily harm. And remember, this is not the only tool that law enforcement has. There are many other tools, warrants, arrests, surveillance technologies, engagement, and nonviolent coercion. So this is one tool that law enforcement has, the most extreme tool. And when and how do police officers use lethal force? Well, on paper, there are guidelines and rules for when they're supposed to use lethal force. And that's what we're going to spend our time talking about today. You find it in national laws. You find it in subnational laws. As I was mentioning, in the United States, there's some guidance in state laws that kind of complements what you find in police department policies. And then, of course, there's police department policies. Now, research on when police use lethal force has found a number of factors that influence when lethal force is actually used. And so it's individual and environmental factors: an officer's gender, personality, level of education, policing experience, stress level in that moment, individual life experiences, the mental state of the subject, the gender of the subject, perceived behaviors of the subject. To give you an example, there's one study that found that an officer was more influenced by their perception of whether or not the subject was recognizing their authority than whether or not they actually felt they were in physical danger. So they were more likely to use force if they felt disrespected, is the phrase used in the study, than if they felt they weren't necessarily in danger or in danger but respected. So these are the kinds of factors that are playing into whether or not police use force. And then, of course, there's racial stereotypes and biases. So what the hope would be in a policy or a law that restricts lethal use of force is to try to restrict and restrain cabin in a way that's human rights compliant when police officers can actually use lethal force. So the two studies that we did focus on these lethal use of force, and I'm going to call them directives because sometimes they're in laws and sometimes they're in policies. And as I mentioned, these directives are intended to provide guidance for police officers as to when, how, and under what circumstances they can use lethal force. They are often the only and certainly the primary source for restraining police in those circumstances. And so our question has been whether or not they comply with basic international human rights standards. Why do we care if they comply with basic international human rights standards? Because that's where the protection of basic rights exists that we've all agreed to. You're probably familiar with the Universal Declaration of Human Rights, the Convention Against Torture, the International Covenant on Civil and Political Rights, all of which the US is a party to. These are the basic treaties that hold states accountable and require them to restrain law enforcement and ensure that they do not overstep and abuse their power against their own citizens. The international human rights principles that we use in this study are found in these three sources. The treaties kind of state the general principles. They're sort of like constitutions at the international level. And then you have a series of documents under the international human rights system that sort of give meat to these principles and explain more what they mean. And so the three relevant documents for us are the UN Code of Conduct for Law Enforcement Officials, the UN Basic Principles, and then a report by a UN expert on the protection of the right to life during the law enforcement process. So those are the three documents. And from these documents that are based in these international human rights mandates, we extracted four principles that are very well accepted: legality, necessity, proportionality, and accountability. And I'm going to explain to you what those mean because they guide the analysis. So the first is legality. And legality essentially requires that a state have a policy that's based in law. So if we believe that law matters, then we give it its depth, its seriousness by placing it in law. And that law must then comply with the international human rights standards. So that's the full satisfaction of this principle: the existence of a law and the fact that it's compliant. The second principle is necessity. And you'll recognize some of these principles actually because some of them have been applied domestically here in the US. But necessity requires that the force that the police officer uses is necessary. It means that it's responsive to something immediate. So the police officer can't use force against someone who they think in 3 hours might be a danger, right? You respond to an immediate harm, an immediate threat. The second is that it be particularized, so that it's not a general fear, but that it's particularized. There's a specific and heightened threat or risk that justifies the possibility that you're going to take a human life. And then the third is last resort, which is you've tried everything else or there's really no other option. And so you have to use lethal force, understanding that this is the most serious measure. The third principle is proportionality. And here the principle is, you meet a certain level of force with another level of force, right? If the suspect has a wooden spoon, you cannot pull out your gun. And so this requires that when an officer is using lethal force, they do so in response to an equal threat of death or serious bodily injury. And then the final one, which many would agree is, perhaps the most important, is accountability. The other two principles, cabin and direct police behavior in that moment, proportionality and necessity. Accountability ensures that there are consequences when a police officer abuses power. And the standard at the international level is that law enforcement must issue a full report to an independent and external oversight body for each instance of lethal force, regardless of the outcome. So it's not based on whether or not the officer missed or actually hit their target, but it was just the use of force that triggers this requirement for accountability. And this also is critical to transparency, because this is the way that we know if officers are overstepping, that there's some system of accountability that comes at the back end of a use of lethal force. The report that we did that was US based, which I'll just quickly summarize here, it was called the Deadly Discretion Report, and you can find it just by Googling or on our website. It focused on the 20 largest cities in the United States. And we found that none of the cities were compliant. All cities fell short of the legality principle, so they were not based in a law that was compliant with international human rights standards. 8 of the cities failed to meet the necessity principle. 3 failed to meet the proportionality principle. And I think all 3 failed because they had what we call fleeing felon exceptions, which allows a police officer to shoot a suspect as they are running away. So they don't pose a threat, they're trying to escape, and it allows police officers to use lethal force under those circumstances. And that's in clear violation of the international human rights protections of the value of life. And then the final principle, accountability, 18 cities failed. Only LA and Chicago were compliant. And this is a good time, I think, to talk about the limits of the study. Both studies, the one that I'm about to talk about, are talking about what the policies say, not what police departments do. And that's a much broader conversation. So the studies that we were doing were focused on what's just the basic standard of what the directives say. Then, of course, it's up to the police departments and to the government to actually comply with these directives. And the reason I bring that up is because, as you can imagine, LA and Chicago have come under criticism in the past for their police departments. And so it's not unusual that their policies were perhaps most robust on the level of accountability because they had been responsive to those criticisms. So now moving on to the global context. So this study, as I mentioned, was commissioned by The Guardian, and we were asked to look in a global scale to see if use of lethal force directives were compliant with international human rights standards. Now, we couldn't look at the entire world because I will tell you, even collecting the policies and laws of these 29 cities in many different languages and understanding what they said took a large team of students. So what we decided to do is we chose the 30 wealthiest countries, and then we had to exclude the United Arab Emirates because despite our best efforts, we were not able to get what we considered full information about what the policies and laws said. So we ended up with 29, and we looked at their laws and policies in 2020 and focused on the largest cities because, as I mentioned, a lot of the directives are at the city level. Our methodology included collection of the laws and policies, and then we had extensive communications with attorneys and academics and policing experts in these countries to ensure that we had fully collected all of the relevant documents. In a lot of countries, the policies are actually split up in a lot of different pieces of legislation, administrative regulations, and policies, and then to ensure that we were interpreting the provisions in the correct way. And then we applied our grading system to each of these. So here is the ranking that we ended up with. And I will say, you will note that New York City is at the top of this ranking. Oh, sorry about that. I think that The Guardian had been hoping that the United States would actually be somewhere at the bottom, is my sense. But that's not the way that it played out. And I'll explain why. But essentially, if you're looking only at lethal use of force policies complying with these 4 basic human rights principles, the US, Mexico, Argentina, Nigeria, and Indonesia are at the top. And I will mention Nigeria and Indonesia, for example, have very new lethal use of force policies. So that probably accounts for why they might reflect a modern conception of principles. And then at the bottom, we have Italy, India, France, and Saudi Arabia. So this is the grading overview. I'm not going to spend a lot of time talking about how we allocated the point system. There were many justifications, but essentially countries could get a total of 100 points, the cities within these countries, and none of them did. Legality was you received the full point allocation in legality if you had a policy based on law that was compliant with international human rights. Here's an example of what legality might look like. This is the policy from Toronto. So here it's referring to the criminal code, it's referring to the regulations, and the policy is based in this law. However, the law itself was not compliant. So so Toronto only received 5 points, but at least it was referring back to a law. We thought that was important because it is a signal to the police that there is the force of law behind these mandates and that it's not just an employee handbook for the police department. Most countries did not comply. Actually, all of the cities did not comply with the international human rights standards in their laws, but all of them, except for Riyadh, had a law that referred to when the police could use force. So there was at least the mandate of the law, even if the law itself was not compliant. Necessity, as I explained before, had 3 elements. And so the cities received 10 points for each of the elements. If they had the fleeing felon exceptions that I described before, they lost 5 points. And here's an example of what we would want to see in a necessity provision. This is from Lagos, Nigeria. So a police officer may use firearms, lethal or potentially lethal force if there is an imminent threat that the police officer will be killed or seriously injured and no other means are available. So you can see the kind of language I'm talking about. That's imminent. It has to be happening right now. And this is an example of a policy that actually received the full point system for immediacy. The fleeing felon example you can find in Madrid. And here it says, law enforcement can fire warning shots to detain a fleeing criminal for a serious crime or shoot at non-vital parts if the fleeing criminal is in possession of a weapon capable of causing serious damage. So here we gave the policy only 5 points because it didn't require that there was an immediate threat to the officer of death or serious injury. So it's not an immediate harm to the officer. The person is running away. It's true that they have a firearm. That's not to say there's no harm, but it doesn't rise to the level of an officer being able to shoot at someone and potentially killing them. This is an example of the particularized threat sub-element to necessity. And here, where we saw defense of others against threat of death or serious injury, we gave them points for particularized threat because it's a threat that is serious enough that actually rises to the level of the officer being able to use lethal force. So this is all signaling to the officer when it's appropriate, when they can pull out their gun or when they can use lethal force in another way. And here is an example of last resort from the UK. All other means remain ineffective and there is no realistic prospect of achieving the lawful objective without exposing officers to real risk of harm or injury. So this is an indication that lethal force is a last resort. And here's what we saw in terms of the cities that we reviewed complying with the entire necessity prong. 5 of the 29 cities we looked at met all 3 elements. 6 failed all 3 elements. Berlin, Tokyo, and Madrid allowed lethal force against a fleeing felon. So they received the 5 points rather than the 10. Now, proportionality. It was either just you had the principle of proportionality in your policy or you didn't, and you received a full 25 points if you did. Here's an example of what a proportionality principle would look like. Again, the language against loss of life or serious bodily harm is an indication of proportionality. There were other policies that actually said that the force needed to be proportional. So in both situations, we gave the cities points for satisfying proportionality because the principle was there. 80% of the states failed to satisfy proportionality, actually allowing lethal force when there was a harm that was not as serious as the use of lethal force. So not balancing the use of force against the rights of the suspect. Stockholm and Mumbai allow police to use lethal force when they believe the suspect has committed a serious crime, regardless of whether the suspect is a threat. So not that additional requirement. In Moscow, the police can use lethal force to defend objects, so buildings, premises, structures, or other objects of the state and municipal bodies. So that clearly violates the proportionality principle. You're potentially killing someone because you're defending property, even if it is government property. All right, accountability. Accountability was the most complicated element to grade because there are so many different forms of accountability that are used in these policies and directives. So without going too much into detail, essentially the lowest level of accountability is internal reporting. So that's basically an officer uses force and a supervisor within the police department has to be notified, and that's it. There are some policies where they needed to notify the division of the police department that gives out the firearms to the police officer. So that's sort of the lowest level of accountability. And from there, you sort of go up. External contact when death or injury occurs, mandatory external contact in all instances of lethal use of force, mandatory external reporting. So contact, just this happened, reporting, having to actually file a full report and explain what happened. And then the full 25 points were only given to policies where there was a requirement that there was mandatory external reporting for all instances. And that's the basic standard. Here's an example. This is from Bangkok. So this is one where the policy only received 5 points, and you'll see why. The people's policeman shall, after using the gun, immediately report to the main person in charge of the gun distribution department. So that's not external accountability. That's not an investigation to determine if it was a proper lethal use of force, but just report to the gun distribution department in an oral form. So that's not a very satisfactory form of accountability. Here's a good example from the Netherlands. So the civil servant who's used force must report it in writing, the nature of the force, and then it goes to a public prosecutor. And so that's one of the external mechanisms that we would want to see, a public prosecutor that is charged with asserting the rights of the citizenry and making sure that the state power against the citizenry was used in a proper form. And on accountability, you will see only Amsterdam, Brussels, and Stockholm received full points for accountability. 8 jurisdictions only required internal departmental reporting with no external contact. And as I mentioned, external contact can vary. So it can be a public prosecutor or in many states, for example, in the US, an independent oversight body that has the power to investigate and the power to issue recommendations. Both of those forms of external accountability were given the full allocation under our grading system. So this is the overall ranking. And I do want you to note, I'm just going to go back. You can see there's a different ranking if you're just looking at accountability mechanisms. And accountability mechanisms are important. You know, as I was explaining before, this is the part of the mechanism that ensures that there is a state response after there is an abuse of force. So it's a different set of states that have really leaned into their accountability mechanisms than the ones that have both given guidance at the outset, but then kind of put their money where their mouth is, I guess, for lack of a better phrase. Okay, so interpretations and implications, and then I will share some patterns and observations with you. So as I mentioned, this study does not tell us which police department is better than another, but it does tell us which state has bothered to issue a written mandate with the force of law that limits the use of lethal force. So if we concede that laws and policies are important as written rules, it does tell us something about what states are willing to do and not willing to do in terms of creating clear rules around police power and use of force. It also means that in the states that scored high on our grading mechanism, that police officers have a clear written mandate available to them to direct and cabin their discretion. So some guidance on when they can actually use this discretion. So a few observations. First of all, not a single jurisdiction had a human rights compliant law. And that's really important to note. These are basic standards. They weren't meant to be a reflection of best practices or a gold standard. It really was just what we expected to see everywhere. And we did not find that any of the jurisdictions had an compliant law with international human rights. And that in and of itself is already problematic. Another observation, is that a lot of these directives were antiquated. Japan's law was more than 70 years old. In a lot of states, the lethal use of force policies and directives just had not been updated. And you can conclude what you want from this. One of our thoughts was that perhaps there was a lack of political will to really prioritize regulation of the security and policing sector. That in a way, it's in the state's interest to keep police discretion broad, and that there hadn't been enough citizen pressure to really ensure a transparent and accountable system, at least in the written directives, even if the functioning of the police department may have actually reflected a different set of issues. Also, many of these directives were limited to the regulation of the use of firearms rather than lethal force. If you're familiar with a lot of the stories that came out of the United States recently, the use of chokeholds and carotid holds, there are many different ways that officers use lethal force that can be incredibly harmful and dangerous. And so 20 of the cities that we looked at just regulated firearms, but not lethal use of force more broadly. And we saw that as a problem because that gives the police a lot of discretion to use lethal force in ways that don't involve firearms. South Korea has a good example of the broad regulation, which is it restricts police use of high risk physical force, which is defined as both the use of firearms and then other kinds of physical attacks. Another observation is that a lot of these policies allowed the use of lethal force for a non-threatening suspect. So directives that allow the use of lethal force upon mere suspicion that a suspect has committed a crime. Some countries authorize lethal force when there's a suspicion of past criminal behavior. Swedish police officers can use lethal force to arrest anyone suspected of murder, treason, and serious drug offenses, irrespective of the nature of the threat that's posed in that moment. Now, you can see why that's a problem. It sort of makes the police officer, the judge, jury, and executioner based on suspecting what someone has done in the past, even if it was in the recent past. So you want there to be an imminent threat that actually justifies lethal force and not the crimes that they've committed in the past. Another observation is overlapping and conflicting policies. So in a lot of these jurisdictions, we found policies that either overlapped and sort of were saying the same thing in many different places, or we saw policies that were just conflicting with different standards or aspect of a standard. So for a police officer to really understand what the rules are, and for a citizenry to be able to hold the police accountable, it makes it incredibly confusing to have the full standards in many different places. In Madrid, there were 3 policies enacted in different years that contained provisions that were absent in the others. And it was confusing for us as researchers to even discern what the standards were. And so it's not really operationally efficient. Another observation is the use of expansive, unclear language authorizing lethal force. There were incredibly vague terms, so numerous jurisdictions provided a list of instances where lethal force is authorized that included threats or imprecise interests such as national security and public order. You can imagine, national security is that phrase that sort of allows a state to do anything. But, the preservation of public order also provides an immense amount of discretion to an individual police officer who may be motivated by all of these other factors that I mentioned at the beginning of the presentation. And so it doesn't really provide a clear directive. Other jurisdictions included a general reference to principles without properly defining what those principles are. And again, this allows for an overly broad discretion for the officer that's employing force, and it also makes it a lot easier for the officer to justify when they are subject to accountability mechanisms. Another observation was the failure to require accountability for each use of force. And as I mentioned, accountability is well understood as being, perhaps the most important, but certainly is incredibly important among the other principles. Accountability mechanisms in some jurisdictions were either internal or they were not a full investigation by an external oversight mechanism. The Defender of Rights in France has the authority to review complaints from the public, but no publicly available policy requires the police to report use of lethal force to this or any other independent oversight body. So there's the possibility of oversight, but not the mandate for oversight. And we thought that that was a problem. There was no clear system for ensuring that there was going to be a process after force was used. And then the final one, I believe, yes, is the lack of transparency. So these policies were difficult to find. The directives were difficult to find. Data on police actual use of force is incredibly difficult to find. There are a number of researchers and NGOs that are trying to collect this data on a global scale. They're doing it through news reports and then partially available data provided by the states. So it's really very, very difficult. And you know, there's an act in Congress right now in the US, the Justice and Policing Act, that's trying to remedy this. But even getting a sense of what force is being used, how extensive it is, whether or not it's appropriate is nearly impossible in most jurisdictions. And the fact that many states fail to make key laws and policies available is really a failure of accountability. As I mentioned, the UA could not even be graded because despite our best efforts in reaching out to all of the contacts that we could muster, we couldn't get anyone to actually provide us with the information. And you find the lack of availability of these directives is just a consistent fact in many states. Okay, so just some final thoughts before I wrap up and we can move to Q&A. The appropriate exercise of state police power is very important. Our fundamental constitutional and human rights rely on it. And ensuring that there is state accountability is important to everyone, you know, even individuals who are not members of these communities that have historically been over and under policed. And what we found in the study is that the most well-resourced states that should have the infrastructure, hopefully the will, the capacity, and the demand from their citizenry to ensure that there's clarity and transparency and accountability restrictions didn't even meet international human rights standards. And many of these countries are extremely active in enforcing international human rights standards on other countries. So it was very concerning to see that that all states that we reviewed, and you know, we can assume that that is the case of the rest of the world, although obviously what we would have to do a separate study to confirm, that all states that we reviewed fell short. And so these questions about reform in law enforcement are appropriate. We need to ask some questions about what is law enforcement doing within the country context, and how can we get the information we need to properly assess where and when reform is needed. All right, I think that I will just leave it at that and turn it over to Professor Ginsberg to hopefully guide us through some questions. Thank you.
Thank you so much for that wonderful and really interesting presentation. It's very rare that us law professors go outside the actual law to look at policies, which of course may have much more impact on the ground. So I want to turn to some of the questions in the Q&A. I'd like to encourage those of you who do have questions to post them. And we're going to start with a question from Tejas Patel, which is, where does the legal system stand if international human rights are violated, but if the legal situation is unclear in a particular US jurisdiction? Would the US court system honor international human rights norms?
Thank you so much, Tejas, for that question. And I actually think that Professor Ginsberg and I can give some thoughtful answers to that. You know, I think it's implied in your question that you understand that the US has a complicated relationship to international human rights legal standards. Despite being one of the main leaders and proponents of the system, we've been really spotty on our willingness to not only be judged against it ourselves, but also incorporate it into our own courts. And that has really changed by administration. So you might be aware that under the former administration, under former President Trump, the US actually withdrew from the UN Human Rights Council, for example, which is the main body that interprets and enforces and discusses human rights among countries. We've just rejoined the UN Human Rights Council. I will be very curious to see how the Biden administration interacts with international human rights law and principles. The last year, actually US-based advocates went to the UN Human Rights Council and requested an urgent debate on the racism that they were seeing by police against African American populations. And the UN Human Rights Council held an urgent debate and then issued a resolution asking the Office of the High Commissioner for Human Rights, which is the part of the UN that focuses on human rights, to issue a report, which came out a few months ago. And there are many recommendations there about what the US should do. So the broad answer to your question is that I do think that the US is very active in the international human rights mechanism and has the potential for also ensuring that there's compliance domestically. The reality of that has been uneven. And it is also true that over time, our courts have become less and less open to considering international human rights arguments. Now, you know, the abortion case that's before the Supreme Court, the Dobbs case right now, has had a number of amicus briefs submitted by international law scholars and by UN mechanisms. So we'll see if the Supreme Court, for example, takes up some of those sources. And at the state and city level, there's actually been quite a bit of progress in terms of legalizing these international human rights principles. So it's an uneven answer, but I'll let Professor Ginsberg add, because he might have a different focus.
Yeah, well, I guess what I'd say is one of the reasons I like your research project so much is that from what we can tell, international human rights norms are not only implemented through courts, right? I mean, that's kind of a conventional way that lawyers tend to think that implementation, everything has to go through courts. But of course, another mechanism for getting human rights norms advanced is to have them actually internalized. And in this example, in the policies of police departments, that's a way to get actual implementation of human rights standards. So I think your work is really highlighting the many ways in which norms can make a difference, even if the courts are not very vigorous in enforcing them. So that actually leads to a question I wanted to ask you, or a follow-up question. This is from David Ennis, which is, apart from laws, are there sets of professional ethical standards that might guide behavior in this regard? Are they local, regional, national? Are they global? Who develops them, and how can they be conveyed and reinforced?
Yeah, I think that's a really good question, David. And what's interesting here is that essentially what police department policies really are employee handbooks. You know, I mean, they're a step above employee handbooks, but they're directives that are issued by the management of a police department about how police officers should behave themselves. And there's all sorts of directives on many, many things. You know, we've been focusing on lethal use of force. Now, I think the question is, what are ethics and where those ethical standards would come from? I think that the way that police lethal use of force policies are drafted. They are drafted in part to enforce what are considered the police officer's constitutional obligations, but then there is also the sense of ethical obligation. And if by ethics we mean, you know, respect for human life and a restraint in taking away human life, that's what the international standards are intended to reflect and what they're trying to implement and make real. But in terms of whether or not there are more kind of national ethical standards, not to my knowledge. And I think police and law enforcement have been famously decentralized. So one of the calls right now has been to nationalize the standards for police in the United States. But I think right now you'll find a lot of variation from city to city and jurisdiction to jurisdiction.
Yeah, one of the reasons I really like that question is because it actually suggests another potential project, which is to focus on ethical, you know, rules. So who knows, maybe in a year or two, we'll have a new project from the clinic. It's a great idea.
Yeah, it is great.
So Paul Bonucci asks, first of all, points out that the finding that no U.S. state is complying with international human rights standards is rather eye-opening. And have you shared these findings with governmental bodies like the Senate's scuttled police reform efforts?
Yeah. So, and actually, I want to say one more thing on the last question, which is that it's interesting from an advocacy perspective and a strategy perspective, what is likely to be most influential for police departments. And I wonder if actually talking about these principles as ethical principles police departments are famously militarized in their infrastructure. And there might be something about the language of ethics that actually could be very powerful from an advocacy perspective, but I'll just leave it at that. We absolutely have shared these findings. And in fact, our deadly discretion report, which is the US-based report, had the widest circulation of, the clinic has done a lot of amazing work, but I think we had 40,000 downloads in a month and a half or something. We were contacted by, I would say, between 15 and 20 state senators that were working on legislative reform within their states, and we provided input in a number of states, including New York City. So we absolutely did at the domestic level within the United States. At the global level, a lot of our research was relied on heavily by both the UN Human Rights Council in this urgent debate and by the report of the Office of the High Commissioner. So if you look at the report of the Office of the High Commissioner, you'll find the global impunity article cited quite a bit. So it gave them this kind of global perspective about what states were not doing. The research I just shared with you was just released in June, so it's actually still quite new. And I think there's much more room. We're working with some academics at Oxford and in Pretoria to contribute to their efforts to actually create a database of lethal use of force policies around the world. And they also have a data management project in which they're trying to create transparency around the use of force. So we're supporting those efforts as well.
Wonderful. We have a question from William Funk about proportionality. So you mentioned the term equal threat, but how is equal threat compatible with shooting fleeing felons? And what's an unequal threat? So I wonder if you could just explain that a little more.
Sure. So it's not, just to be clear, the fleeing felons exception was viewed by us as a violation of the proportionality principle. Absolutely. What we did, we gave them some points under necessity because there were elements of the necessity provision that were included in some of these policies. To be honest, we tried to be as generous as possible because we wanted to give states credit for the things that they did do. But of course, shooting a fleeing felon is not proportional, right? The proportionality principle requires that if you engage in lethal harm to another human being, you better be under the threat of lethal harm by that human being. And that's what the proportionality principle requires. So it is absolutely in violation of that.
Mm-hmm. Richard Fisher asks an interesting question, noting, first of all, that, we're up there pretty high, but we're still failing in many of these central criteria in your study, and sort of illustrating a general gap, perhaps, between US ideals and our actual implementation of practices and policies on the ground. So the question is, how can we move forward without alienating local police departments and inflaming these debates, which tend to be, partisan and ideological? Specifically, do US mayors and chiefs of police know what international human rights standards and mandates are?
Yeah. So I'll tell you a little story. When Mayor Lightfoot was engaged in negotiations around the consent decree, and I think it was at the point that she issued a letter in which she was rejecting actually a lot of the requests that the body that had been put together to make recommendations about what the city of Chicago should do. She rejected a lot of those requests, and advocates were very frustrated. But in that letter in which she rejected the request, she actually cited to our deadly discretion report as evidence that Chicago was doing really well because Chicago was at the top of our ranking of non-compliant cities. And so I did an op-ed in the Chicago Tribune in response because I was very upset by this because, the reason that Chicago has a more compliant policy is because of the criticism that Chicago has been under for so long, and a police department that abuses its power quite regularly. And so our policies look better. Now, like I said, this is a limited study that's talking only about the language of policy and language of the law, and not about how it's managed, how the training mechanisms work, how they're implemented, whether or not the police care. That's a much broader question that's incredibly important. So I tell people to take that ranking with a grain of salt, because what we were hoping people would focus on is that everyone failed, not that some cities failed a little less than others. And then in terms of how not to alienate, so I think that answers your second question, which is that yes, mayors are paying attention. Mayors are paying attention anytime there's a criticism of their police departments. And I think the language of human rights, even though the U.S. has had a complicated relationship to human rights, many of the movements that we're seeing, if you think about the Black Lives Matter movement, these are explicitly human rights movements, that are reaching beyond constitutional language and are really about what are the basic rights that are just due to people because they're people. And so we actually think this language can be quite powerful. And then in terms of inflaming, I'll say there's a time and the place for a little bit of inflaming. And then you have, reasonable conversations where you all try to reach some kind of middle ground.
There's so many wonderful questions, so I apologize that I can't get to all of them. John Balfe, mispronouncing the name, but asks if you have views as on the question of why countries are failing as opposed to how they're failing. I love that question. It's like a social science question.
Yeah. I have views. I mean, I will say it's speculation, but my sense is that it's better and it's easier for a state to not commit to too much in writing. And I think there hasn't been up until now a demand from people to have transparency on this. It's surprising, right? If you think about all of the data that we collect on so many elements of our daily lives, and the fact that we don't have data, reliable, consolidated, available data on when law enforcement is killing citizens and under what circumstances, or even just shooting at them, that's strange when you think about it, but it is a pretty consistent thing. So my sense is that it hasn't really been in the state's interest to do this and that the people haven't demanded it. But I do think that that's going to change soon.
Mm-hmm. Marty Lovelace asks whether you've seen an increase in additional unilateral internal investigations of police departments in light of the recent spate of police brutality, issues and awareness of that issue. You think that we're at a moment of increased introspection in departments?
I will answer that with a grain of salt. I think that there is more attention. I think police departments have been held accountable in various states. I know there are similar movements happening in various Latin American countries, in various African countries. So I want to say yes. Now, whether or not it's enough, I think is a different question. And there are a lot of dynamics at play, that resist reform. And there's also a lot of calls for reform that have different ideas about what reform would look like. So I think we're at the beginning of a conversation. I think the federal legislation that's before Congress right now will go a long way, just in terms of limiting the circumstances in which lethal force can be used, and then also making data available. And that will also make it easier for us to be reflective about how law enforcement is doing its job, whether it's doing its job well or not. I have some specific ideas as well about reforms that are just clearly needed. I'll give you an example. You may or may not be familiar with the Supreme Court case, Gonzalez versus Castle Rock. It's a case in which the Supreme Court found that a domestic violence victim who had called the police in Colorado several times because her ex-husband had kidnapped her children. She had an order of protection, a restraining order against him, and called the police several times and said, my children are gone. She had 3 little girls, and I know my husband, he's had mental health issues in the past. Well, the police ignored her calls 16, 17 times. And at 3 a.m, the ex-husband pulled in front of the police station, opened fire, and they found that the 3 little girls had been killed earlier that day in the back of his truck. And so this case went before the Supreme Court, the plaintiff, the appellant, saying, the police should have listened to me. I had an order of protection. And the Supreme Court actually said that a domestic violence victim has no expectation that the police will enforce a protective order, an order of protection, because the police need discretion to decide what they're going to prioritize. And on that evening, the Colorado police had saved cats out of trees. So it was a very egregious case. That's the kind of reform we need. What are orders of protection if they're not something the police needs to step in? And if the police are only going to step in when it's convenient, then we need to find another government service that can actually do that important job.
So I'm going to ask the last question and ask you for a really quick answer since we're almost out of time. This is
Yeah.
just on this very point, which is Teal Brink is asking about greater mental health, use of mental health personnel in interactions with people, which are traditionally, of course, the product of, something that the police would do to supplement that. Is there any support in international human rights law for that kind of norm or that kind of effort?
Absolutely. And I love that question. And it is, it's incredibly, there, first of all, there's so much research that demonstrates that, that when the police show up in a situation where there's a mental health crisis, that often they just escalate and make things worse. And so there's many other government services that we could employ and fund that would deal with those situations in a better way. And then in terms of international human rights principles, yes, first of all, there's a convention on the rights of the disabled that actually calls for that kind of response rather than a security oriented response. So many advocates have argued that we've just basically dumped all of these things in the police's, bailiwick that really require other responses. That's my quick response.
Thanks for the quick response, and I'll turn it back to you, Andrea.
Thank you. Thank you, Professor Flores, for sharing your research with us, and thank you for your work in this crucial area. And thank you, Professor Ginsberg, for being here to extend the conversation so thoughtfully. Rights matter, but conversations about rights can be polarizing, confusing, and frustrating. So Professor Flores and Ginsberg have traveled the world getting into the weeds of global human rights debates. On Entitled, they use that expertise to explore the stories and thorny questions around why rights matter and what's the matter with rights. So please check out their podcast. It is a production of the University of Chicago Law School and the award-winning University of Chicago Podcast Network. We also invite you to listen to Big Brains, a podcast featuring the pioneering research and pivotal breakthroughs at the University of Chicago and beyond. In episode 9, Professor Flores discusses her report on the abuse of migrant children, the history and future of immigration policy, and her career as a human rights advocate. Visit bigbrains.uchicago.edu or find Big Brains wherever you listen to podcasts. Thank you again, and we'll see you soon.